I'm Ralph Sanders, and this is Aging with Dignity. Today we're talking with Janet L. Smith of Janet L. Smith Mediation Services. Good afternoon, Janet.
Hi.
Janet has been a licensed attorney in the state of Washington for over 3 decades and is now retired from her elder law practice. Janet, what brought you to elder mediation?
Well, in my elder law practice, a large number of the cases that I handled involved really significant family disputes, a lot of conflict, and I always tried to take a collaborative approach rather than an adversarial approach with those cases, and I feel that working out the solution usually got a better outcome. And a lot of my cases went to mediation, and I felt that with my skills and experience, especially dealing with individuals suffering from dementia, that I would be able to bring a unique perspective to the role of the mediator. So in 2008, I did the mediator training at the University of Washington and added that to my practice.
I see. So what is mediation?
Mediation is the name of a process for parties voluntarily working with a neutral third party to craft their own resolution to a dispute.
Okay, and why is elder mediation different?
So what elder mediation means is generally that there is one of the parties or the subject matter is an older person or a person with a disability, and generally the parties to the dispute are close. They're family members or close friends or spouses, and it requires a different skill set for working with families and also working with an elder who may have some diminished capacity.
I see. So you usually work with elders and with their families.
It all depends. The elder is often the subject of the dispute, and I always take a case-by-case approach to how much the elder themselves can participate in the process.
What are some of the issues that you commonly run across in elder mediation?
So one theme that runs through almost all disputes in the elder law context is the tension between a person's autonomy and their safety. So we often have 2 factions in a dispute. One that wants the elder's stated wishes to be followed, perhaps like something of aging at home, even if that has some elements of risk. And another faction wants the elder to be protected, their health and their finances to be protected, even if that is different from their stated wishes. So there's always this tension, this balancing act between those 2 concepts.
So I've heard that in the state of Washington, an individual's autonomy overrides almost anything. Do you find that to be true?
Yeah. The law and the reality of a condition like dementia often don't overlap real well, because someone can have lost the ability to make a good decision about where they're going to live or how they're going to spend their money. They may have lost the ability to understand consequences. They may be subject to exploitation, but it can be very difficult to impose, to take away their rights or to impose a solution on them, which is one of the reasons why mediation is a very, very useful tool in resolving some of these disputes.
I see. Well, what if the family doesn't know what the mediation is about?
So I tend to use the word mediation when there is a specific issue that needs to be resolved, such as who is going to be in control, how are the finances going to be managed, where is the elder going to live. And I tend to call the process a facilitated family meeting if the family simply knows that something's not working, that they're not communicating well, they can't make a plan, but they really don't know what the issues are. And then it's a very similar process, but the third-party facilitator can help the family right at the beginning understand, okay, well, what are the issues that need to be resolved? Once you know the issues, what are some of the options? What are some of the ways that other people have handled this situation? And then guide the family towards creating a plan to resolve those unmet needs.
So are these mediations confidential?
Yeah, that's one of the great things about mediation is that there are rules that what is said in the mediation cannot be used outside of that setting with a very few exceptions. You know, for example, if the mediator learns about elder abuse or child abuse, you know, there are some exceptions to when things can be reported. But for the most part, what happens in that room until a final agreement is put down in writing, that all stays private and confidential. It makes it a safe space for people.
So about how long does a mediation typically take?
One of the advantages of using mediation to avoid litigation is the speed. That usually a mediation can be scheduled fairly quickly, you know, within a few weeks, depending upon the mediator's availability and the availability of the parties. And then the whole process wraps up in a period usually of a couple of days rather than the months or years that it might take to resolve a matter by going to court.
So can we say that mediation then is quite a bit less expensive than taking a case to trial?
Yes, the cost savings is really pretty significant because the mediation just focuses on getting things done. It's results oriented, it's future oriented. Sometimes we tell the parties we can't mediate the past. You each have your own version of what happened in the past. We don't need to resolve that in order to resolve what's going to happen going forward. So it can save a lot of money in discovery costs, in legal fees, and produce really a better result for the parties.
I see. So you might separate the two sides and then go back and forth between the two sides, working things out.
So, sometimes that helps separate. One of the things that families have difficulty doing is separating the problem from the people. They have such an emotional response to this family member that they've been dealing with all of their lives that they can't see past those emotions and really look at, well, what are the nuts and bolts of the problem that have to be solved? And that can be one of the real advantages of having that third party intermediary to really focus on the problem and not the personalities.
You mentioned that sometimes you deal with elders with dementia. Mm-hmm. What's the process? What's involved when one of the parties is an elder with dementia?
Yeah, so it's always a sliding scale. There's no one answer to whether a person with diminished capacity can participate in the mediation. Sometimes there is some memory loss or some cognitive impairment there, but the issue is their life. And so they have to be involved, even if they're not processing the way they might have as a younger person. So it's important to me, and it's important to the process, that we always honor the voice of the elder. We try to discern what it is that they want and what their historic values and preferences have been, and to honor that to the greatest extent possible while still preserving their safety if they're not able to understand all of the consequences of a bad decision.
I see. So you're an attorney. Do you need to have an attorney involved in mediation?
You don't. I sometimes will work with families before anyone has retained an attorney, and that can be very helpful to work out the issues before positions get so entrenched that the parties just can't do anything except take it to the next step with filing a petition for guardianship or filing a petition for a restraining order. Attorneys, on the other hand, can be very helpful to the process. They can help their party focus on the issues going forward. They can help their party work towards a resolution rather than, most attorneys also want to avoid the litigated resolution if there's a way to do that, because litigation is just not just so expensive, but so risky.
So do you have any examples of mediations that you've done that might demonstrate some of the things you do?
This case involved a dad who had one son who lived out of state. Dad had been married for more than 50 years and his wife had passed away, and he had recently married a new wife, much, much younger than him. And the son was concerned about both the father's health and welfare, not thinking that the new wife was providing good care, and also financial spending. Dad, of course, in a lot of these cases, there is money, and Dad had some significant assets, and the son was very concerned that the new wife was both neglecting him and financially exploiting him. So Dad very much disagreed with this. He told the son, "Butt out of my life. I have the right to marry who I want to and live where I want, and you're just, interfering. It's not your life." And, Dad thought that the son was just worried about his inheritance. The son thought that the wife was unduly influencing Dad and isolating him, so not letting the son, have private phone calls and visits. So much conflict, very entrenched. The parties were not speaking to each other. And so it came to mediation because the son filed both a petition for guardianship for the dad and a petition for a restraining order against the new wife. And the parties agreed to mediate this case before the court hearing. And it took a lot of work. Dad probably had some lack of insight into his care needs, but he definitely knew what he wanted. And basically the process was I met individually with each of the parties, and then we had a nice long day working together, mostly in the same room. And the parties were able to reach agreement that was acceptable to everybody so that the court actions could be dismissed. And that involved getting some professional help. The dad and his wife agreed to hire a care manager who would advise on whether the care in the home was adequate, and that they would follow instructions if the care manager wanted more care in the home. The dad agreed to put almost all of his assets into a trust with a professional trustee. So his house, his investments, all of that was protected, but Dad and the new wife got to keep a checking account, which would always have a significant amount of money in it that they could spend any way they wanted. The family, one of the things that mediation can do is it can go beyond issues which you could deal with in court. For example, you can't agree to a will contest while somebody's alive, but the parties agreed to work out what was going to happen to Dad's assets after he died, a distribution involving both the new wife and the son, and they worked it out that this is what it's going to be. And they put consequences into their decision. If people don't do what they're supposed to do, then certain things would happen. And they worked out visiting so that the son would not feel isolated from his dad. There would be set times for phone calls. There would be set times for visits, and the wife wouldn't interfere with that. So they worked out all the details. And one of the things that was really, really heartening to me is with this process, we don't promise that we're going to heal relationships. We usually focus on the issues and we try and resolve those. Sometimes the divisions still stay intact. But at the end of this really long day, with a family that had stopped talking to each other, at the end of the day, Dad and the son embraced, and they were heard as they were leaving the office, making plans to have dinner together that night for the first time in years. So, no way to know if the relationships were all kumbaya forever after that, but it was a start, and that family got to stay out of court and resolve their issues in a way that they could all own that solution.
Well, excellent. Janet, thank you very much for talking to us about elder mediation. This is Aging with Dignity. I'm Ralph Sanders. Today we've been talking to Janet Smith of Janet L. Smith Mediation Services.